Alex here with part 3 of the Corazon real estate series, and as with my previous videos, please take a look at part 0 if you haven't seen it yet. Again, that the child custody portions of part 0 can be disregarded, but the underlying purpose of the series to give my viewers one big example of my, I don't think it was very long, maybe 1 year long, 2 year long, probably less than that, a dispute with my landlord, Corazon Real Estate. And it's the purpose of these videos is to give you guys an example from beginning to end in chronological order of how I went through representing myself in that situation. This is the judge's order denying temporary restraining order request. And my mindset at the time, I remember, was, pretty poor. I felt like, as I mentioned in the last video, same feeling. The system wasn't fair, that landlords were able to break all kinds of rules and nobody was going to do anything about it. I really think that it comes down to meta rulings as to why this happened. I think that the judge, sorry, not this particular denial, I think just overall generally, and maybe I'll talk about that at the very, in the last video. That's probably a good idea. So I'll wait till the last video to talk about how I think meta rulings really led to this kind of situation going in this direction. But for now, I mean, even though I've mentioned that I feel like the system's unfair, in hindsight, today, as I look at this, I feel like, of course, he's going to deny it because I don't think that this was the correct way to deal with this problem. And I mentioned in the last video in detail why I think the correct approach was to file an appeal, not to use this mechanism. So I'm going to, at this point, say, let's go ahead and take a look at the judge's order and see if I can sort of recall any other details from what was going on at the time, or even consistent with my analysis in the last video. Here we have the judge's order denying my request for a temporary restraining order. Indicates he is in receipt of the ex parte motion. I am requesting the court grant the temporary restraining order pursuant to the rules of procedure, and that I've withheld rent in accordance with this statute, and that the defendant is improperly evicting. The court has thoroughly reviewed the plaintiff's motion and exhibits. They're saying that I admit in the exhibit that I'm intending to move out anyway. Additionally, the 30-day notice to vacate states. Therefore, the document was signed. So he's saying there's no irreparable harm if you're moving out early. On the one hand, I could say that that's a moronic, sort of analysis, because I'm not talking about moving out at the end of the 30 days. I'm talking about being forced to move out early. But on the other hand, I could also say he's right, because irreparable harm isn't necessarily about recovery for somebody breaking the law. He's not saying that I can't recover monetary damages for them evicting me early. He's just saying I'm not going to be irreparably harmed because I'm going to move out early anyway. So it's a creative way that he has found to deny the request. I think there were probably several other ways that he could have denied the request, but it does make sense to me. You can't claim irreparable harm if you're ultimately going to move out anyway. You can claim monetary damages for the law being broken. That's still on the on the plate, but you can't claim that you're going to be irreparably harmed if you just are forced to move out from a place you're going to move out anyway 2 or 3 weeks in advance. So it's really about distinguishing the remedy, not necessarily picking apart the judge's analysis. So I do think that this was a creative and proper way for him to deny the request, and I do think that it makes sense based on what I stated in the last video anyway. And there's some footnotes here. Okay, yeah, I'm not, this isn't gonna, he's just citing the laws and I guess the subsections. A certificate of service indicating this document was mailed to both me and the real estate agent, and that's it. Going into the aftermath, I didn't file anything, so I incurred $0 in costs. The landlord didn't file anything, so he incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. The landlord would have ultimately gotten an attorney which would have reviewed this document, and probably they would have put at most 15 minutes into it, which is going to come to $62.50 in attorney fees for the landlord. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.